Getting started, our first presentation today is Bees, Schools, and Alternatives. Travis Howard, who is the Deputy Agricultural Commissioner for Sonoma County Department of Agricultural Weights and Measures, will be presenting. This is our first presentation today for Laws and Regs. With that, Travis, I will unmute you. If you want to share your screen.
There we go. Can you see it?
Yep, we can see it and hear you.
All right. Well, good morning, everyone. Thank you, Cindy, for hosting this seminar. We appreciate it and inviting our department to participate. So I don't know if you guys remember, historically, this is the same day, the first Thursday in December, that our department would host a annual grower workshop at the Santa Rosa Vets building. We didn't do that last year and not this year, but this was a way for our department to participate and present on some laws and regs and help you all get some continuing education hours. So like Cindy said, my name is Travis Howard. I'm the Deputy Ag Commissioner here in Sonoma County, and I supervise and lead our Pesticide Use Enforcement program. So I kind of have a three-part presentation this morning. Part one, I'm going to talk about pesticides toxic to bees and notification to registered beekeepers, those requirements. Part two, I'll get into pesticide use near schools regulations. And third, lastly, documenting alternatives when applying for a restricted materials permit. So jumping into the pollinator protection regulations, which have been on the books for decades, you might ask why the revamp now? I think we can all agree how important of a role pollinators have in both our natural ecosystem as well as agriculture. So bees may not have a huge impact on your commodity, your production. I think a lot of you participants are in the production of wine grapes specifically, but I think we all understand the importance to protect pollinators and protect all California agriculture, because there are many crops that obviously do rely on pollinators. So in 2014, there was a presidential memorandum. It was to establish pollinator health task force, develop a national pollinator health strategy, which included pollinator research action plan, public education plan, and public and private partnerships. Ultimate goal, obviously, to increase and improve pollinator habitat. So California Code of Regulation 6650 basically defines what pesticides are toxic to bees. So in the regulation, talks about labels which include words such as toxic to bees or harm to bees, regardless of any modifying words like moderately. So these statements might not be always prominent on a label. They might show up in different parts of a pesticide label. Here we can see it in the environmental hazards. Specifically says this pesticide is highly toxic to bees. So again, the statement will not always be in the same place on the labels. Here you can see there's statements saying to avoid possible harm to bees, it is advisable to apply in the early morning or late evening hours. Some resources for you as growers. There's a really good resource catalog from the Oregon Extension Office. It lists many specific pesticides and whether or not they are toxic to bees. And then also we urge you all growers to talk to your PCAs. So So bees are considered to be inactive from 2 hours past sunset to 1 hour before sunrise, or at temperatures below 55 degrees Fahrenheit. Bees may forage from hedgerows, cover crops, or collect water from areas with pesticide residues. Contaminated water or pollen may kill larvae back at the hive. So in fact, there's an article that was just published by UC Davis called Pesticides Can Affect Multiple Generations of Bees. It's a study finds reduced bee reproduction for 2 years. So I'll maybe share the link to that article in the Q&A when I'm done here, but I recommend everyone taking a look at that article. So Food and Ag Code 29041 and 29043 states beekeepers must register their hives with the County Ag Commissioner's Office. And that law also protects the location of those hives. That information is confidential. And that's protect hives from theft. And yes, it does happen, unfortunately. The California Code of Regulations 6652 states those beekeepers who desire advance notifications of applications of pesticides shall inform the commissioner of a specific time period in which they would be available to receive advance notice from the persons applying the pesticide or pesticides. So who needs to notify beekeepers of applications? So California Code of Regulations 6654 states each person intending to apply any pesticide toxic to bees to a blossoming plant, that's very key, prior to the application, inquire of the commissioner or of a notification service, which I'll talk about in a minute, designated by the commissioner, whether any beekeeper with apiaries within 1 mile of the application site has requested notice of such application. If the person performing pest control is advised of a request for notification, he or she shall notify the beekeepers at least 48 hours in advance of the application, of the time and place the application is to be made, the crop and acreage to be treated, the method of application, the identity and dosage rate of the application to be applied, and how the person performing pest control may be contacted by the beekeeper. So this basically allows ample time for beekeepers to move or cover their hives. It doesn't mean that the application can't happen. But remember, as applicators, you are still responsible for the protection of persons, animal, property, and always follow the label. So bewarecalifornia.com and beware.calagpermits.org is where you could go to perform a bee check. So you can use your CalAg Permits login. A bee check informs you about whether registered hives are within a 1 mile radius of the intended application. Registered beekeeper contact information if they want to be notified. And again, you can use your CalAg Permits login to do that. We've been trying to give folks CalAg Permits logins no matter what, even if you're choosing not to submit pesticide use reports online, because there's other resources and things to use that login for. So if you're not a computer savvy person, which I imagine if you're on this webinar, you could figure this out. But if you are not in CalAg Permits and want to log in, call our department. We'll set you up with a login. If you feel like that's too difficult, it's still your responsibility to do a bee check, and you could contact our office and we can basically do that for you, run that query. So when you do a bee check, the system will document your check. First and foremost, I would suggest to any of you growers to take inventory of what products you have in storage and what products you intend on using throughout the growing season. Obviously, we know pest pressure changes throughout a year, but take inventory and document any of those products that are toxic to bees and that would require a bee check. So here is the Beware website where you would log in to conduct a bee check. So this is where beekeepers, pest control advisors, and growers can all log in. So currently, we have 62 registered beekeepers in Sonoma County, which equate to 290, and that's about 18,000 plus colonies. And that's in Sonoma County. And Sonoma County is becoming more and more a destination for out-of-county folks to bring their hives in to overwinter, I think just because of our mild climate. So just know that throughout the year, you know, these hive locations will change and move around. All right, getting into part 2, pesticide use near school sites. Again, I know we've been shoving this regulation down your throat for the last 3 years, but it is still very much important. We have had a few issues with folks not submitting notifications, but for the most part, I think, at least here in Sonoma County, we have very good participation and compliance with these regs. So currently in Sonoma County, we have approximately 280 production agriculture sites that fall within a quarter mile of one or more public schools or licensed daycare facilities. So we do have quite a few. So California Code of Regulations 6690 basically defines some of the things in regulation. So pertains to pesticide applications made for the production of an agricultural commodity within a quarter mile of a school site. So again, production ag commodity, we're not talking structural applications or maintenance gardener applications. To define school site means any property used as a child daycare facility or for a kindergarten, elementary, or secondary school. This includes all areas of the property used on weekdays by children who attend such facilities or schools, or other properties which are identified by the commissioner, such as a park adjacent to a school that is used by the school for recess, sports, or other school activities. This does not include family daycare homes and any post-secondary educational facilities attended by secondary pupils, private kindergartens, elementary or secondary schools, or vehicles or bus stops, which are not on school site property. So California Code of Regulations 6691 is what actually restricts certain pesticide applications, when and where, what kind of equipment and all that. So pesticide application restrictions apply Monday through Friday during the hours of 6 a.m. to 6 p.m. And depending on the distance from the treated area to a school site, the application to be used and the type of pesticide being applied. The type of pesticide is not the product formulation, but ultimately the final form applied. An example, the powder is mixed with water and then applied. This is considered a liquid application. So during these time periods, the operator of the property and the applicator shall assure that an application is not made within the distance of the school site as specified here in my next slide. So this is when there must be a minimum of a quarter mile distance restrictions for applications using aircraft, air blast sprayer, or other ground application equipment with a pump that delivers spray into an airstream created by a fan, sprinkler chemigation, using a dust or a powder, or a fumigant. So for most of you, I think participating today, a lot of you in the grape industry, the likely equipment that you'll be using is air blast sprayers. So when must there be a 25-foot distance restriction? That's when using a ground rig sprayer, but again, excluding the dust, powder, or fumigant field soil injection equipment, again, excluding a fumigant, or other application equipment not identified in this section, such as a drip or flood fumigation equipment. And when is there no distance restrictions? So that's when the application is made within an enclosed space, such as a greenhouse, but again, excluding fumigants. The application is made using bait stations. A pesticide is applied as a dust or powder using field soil injection equipment. When a pesticide is applied as a granular, flake, or pellet. However, when the pesticide product formulation is applied as a fumigant or applied by aircraft, then we go back to the quarter-mile distance restriction. An application is made using a backpack sprayer. However, when this type of equipment incorporates an air blast sprayer or is used to apply dust powder, the quarter-mile distance then applies. So we all know there's the backpack sprayers that you just hand pump and you direct the spray, to the plant or the ground. That's no distance restriction, but when you get those air-powered, gas-powered backpack sprayers to, blow your fungicide into the canopy, then you're in the quarter-mile restriction. An application is made using a hand pump sprayer. However, when this type of equipment is used to apply dust powder fumigant, then again, the quarter-mile distance restriction applies. All right, so continued. There's no distance restrictions when school classes are not scheduled for the day of the application. The child daycare facility is closed during the entire day of the application. So in addition to the time period and distance restrictions, fumigants cannot be applied when school classes are scheduled or child daycare facilities are open within 36 hours following the fumigation. There can be written agreements between the property operator, the school, and our department or the commissioner. Those may be accepted as long as the agreement provides the same or greater level of protection. So there can't be an agreement between those parties that are less restrictive. If anything, they would need to be more restrictive, and all parties would need to be in agreement. I'm sure a lot of you have seen this chart here. It's very helpful, but it basically defines all the stuff I just talked about, the distance to school sites depending on equipment and pesticide types. So if you don't have this, you can find it on DPR's website or contact us and we can provide it to you. But it's a nice tidy chart that will help define all those at a glance, let you know what kind of setback or distance requirement. So the third part of the pesticide use near schools regulation is California Code of Regulation 6692. So this states the property operator shall provide annual notification of expected pesticides no later than April 30th to be used from July 1st of the current year through June 30th of the next year. So this notification must be provided to the principal of the public K through 12 school, the administrator of the child daycare facility, and the county agricultural commissioner. There is a paper copy of this notification form we can provide to you, but most of these notifications are being done through CalAg permits using your CalAg login. Those of you that are renewing this year, renewing your operator ID or restricted material permit, as soon as you come in and renew, it will automatically allow you to start submitting these annual notifications. Those of you that have a operator ID or restricted material permit that is still valid for another year or two, you could go in now and submit those notifications. But just remember, they need to be submitted and done by April 30th for the July 1st start of the growing season. So the notification must be in writing and include specific information, must provide the notification within 30 days of assuming control of a property. So if you're a vineyard manager and you're picking up a new site, when you add that to your operator ID or restricted material permit, we would note and tell you, and it would be noted on your permit or op ID, which sites of yours fall within a quarter mile of the school site. So if a pesticide to be used was not included in the initial notification, the operator of the property shall provide this information to the school site and commissioner at least 48 hours prior to the application. So say you have some different pest pressure come up and you want to use a product that wasn't on your initial annual notification, 48 hours prior to the application, you need to make sure you log in and make an amendment to your notification to add that new product or new active ingredient. The property of the operator, the property operator shall retain a copy of each annual notification for 2 years and make them available to the director or us, the ag department, upon request. The commissioner shall retain a copy of each annual notification for 1 year. So every time a notification is submitted, we can see those in CalAg permits. So this is what the annual notification looks like on CalAg permits. Unfortunately, we've issued about 10 violations since 2019 for some folks not submitting annual notifications. So please, everyone, make sure you do those and get them turned in. So lastly, I'm going to talk about documenting alternatives when applying for a restricted materials permit. So the EIR functional equivalency evaluation requirement. So in 1976, an opinion by California Attorney General determined that the issuance of a county permit was subject to the requirements of the California Environmental Quality Act, or CEQA, and therefore required an environmental impact report for the pesticide permit. So the restricted materials permit program was developed as an alternative program to provide for basically an abbreviated environmental review procedure that serves as the functional equivalent to a full-scale EIR, which would normally be required by CEQA. So although the state and county ag departments do not need to prepare an EIR, documentation of environmental impacts, mitigation measures, and alternatives are required when issuing a restricted material permit. So the restricted material permitting process was designed to meet these requirements. This program requires ag departments to issue time-specific and site-specific permits for the agricultural use of restricted materials. So the requirements for evaluating potential environmental impacts of proposed restricted materials permit, there's 7 steps that we follow. 1 is hazard identification, 2, identifying sensitive sites, 3, determining the likelihood of adverse impacts, 4, existing mitigation measures, step 5, additional mitigation measures, step 6, considering alternatives, and step 7 is a risk-benefit analysis. So step 7 is what we're focusing on today, and California Code of Regulation 6426 requires the permit applicant or the grower and his or her pest control advisor to consider alternatives to the use of a restricted material before applying for a permit. So while this specific requirement is directed at agricultural use, the general requirement to consider alternatives applies to all permits. To determine compliance with this requirement, the ag department should ask the permit applicant to identify the alternatives that were considered and document his or her response. So that's the biggest difference. In years past, we had these discussions. Hey, have you considered alternatives? What are those alternatives? Now we're being required to actually document these responses. So the restricted material permit applicant will be required to fill out called an alternatives considered worksheet to document both non-chemical pest management practice alternatives, which would be, hand weeding, mowing, etc., and 2, reduce reduced risk chemical alternatives such as organic or 25B products. So it's not necessary for us to, tell you what those alternatives are. You're telling us what alternatives you've considered. So I don't know, for instance, if you're applying for a 2,4-D permit, some chemical alternatives that weren't restricted would be, glyphosate, something like that. And then obviously non-chemical pest management would be hand weeding, mowing, disking, something like that. So I'm kind of wrapped up with my presentation. I just wanted to end with a quick update on our permit season. We did send out letters to all folks that are due to renew either their operator ID or restricted material permit. So please give our office a call and schedule an appointment. And if you still need continuing education hours, I recommend you go on DPR's website and look for some additional courses or contact our department. We do have a list of some online courses and some options that we can provide to you. So with that, if there's any questions.
Yes, thank you, Travis. Michelle's going to pop on. We do have currently one question in the Q&A for you.
I can see the question here.
Hi, sorry, I'm just turning off the sound of my heater, so my apologies. The question is, does the state have any feedback from the school administrators about how they are handling the notification information? Are they able to handle the data? Have they had to hire additional staff? Do they feel that the background to understand the data stream?
So no, short answer. I honestly don't know what schools are doing with this information. I think some administrators turn around and provide that to the parents, but I don't know, to be honest with you, if many schools are doing anything with it, to be honest with you.
There are a few other questions. What measures are there to protect native bumblebees?
I mean, all the regulations I spoke to earlier. If the product is toxic to bees, doing a bee notification. Obviously, those are wild or native, so it's not going to pertain to a beekeeper themselves. But if a product is toxic to bees, the label is going to state that. And again, it's your responsibility as an applicator, one, to follow the label. And if the label is toxic to bees, it likely says do not apply when bees are active. And two, it's ultimately still the responsibility of applicators to be aware of their surroundings and protect persons, animals, and the environment.
Got it. The next question. I work in an indoor cannabis facility. Would the beekeeper notifications and school notifications still be required since the pesticide use is indoors and contained?
Yeah, so as far as the schools, like I talked about before, there would be no distance restriction. So yes, you still have to do a notification, but you would not need to school. So you would need to do your annual notification, but you would not be restricted on basically when you make that application.
Okay, so it looks like those are our questions. We are going to move on to the next presentation.